One thing that we've been getting, I get messages for this all the time on locals. People want the template for anybody who needs the letter if their employers are requiring vaccination. That is, I forget, I don't know where that is on locals, but it's on locals somewhere. So you just have to ask the community.
It's pinned at the top of the board at vivabarneslaw.locals.com. And this is a good bridge. There's a bunch of different potential vaccine mandate related lawsuits, either pending or coming. And here's what sort of the legal scope looks like. So the first thing is that there will be people challenging the FDA. You get to file what's called a citizen petition. Part of the whole process of the way the FDA works is they want to make sure informed consent and your right to petition the government under the First Amendment. That's the right that Amy Coney Barrett couldn't remember in her own Senate hearing, by the way. But that both of those rights are enforced through the FDA drug approval process, whereby you as a citizen get to file a petition with them identifying any concerns that you have, or you can comment on an existing petition. And so, for example, the Children's Health Defense and Robert Kennedy and others have filed a petition back in May. There's over 30,000 comments on that. Children's Health Defense may be filing a challenge. Other organizations and other individuals may be filing a challenge to the FDA's authorization, looking for limitations on its existing authorization, revocation. What you can do is you can ask under the Administrative Procedures Act, you can say the government's unreasonable delay in answering my petition, or they've answered it, but their answer is unsatisfactory, or they've exhausted their time limit to answer, and so it's taken as a constructive denial, and challenge it. And you're challenging an agency action, which can include in getting a declaratory relief or injunctive relief under the Administrative Procedures Act. And it's whether or not they were arbitrary or capricious. And mostly what that's about is, did the FDA follow its own rules, follow its own procedures before taking any particular agency action, whether that's issuance of a notice like their fact sheets, whether that's an issuance of a approval of a vaccine as emergency use, or for a full actual FDA approval, and all of those components. So that's one area we're going to see litigation. Another area we're going to see litigation, and already is pending, are where various state actors have imposed obligations on mandates on vaccines. So the Indiana University case is pending. There's an emergency injunction request pending before the United States Supreme Court. Here's what's kind of shocking. Indiana University argued in the lower courts, the Seventh Circuit and the District Court, argued that Buck v. Bell is still governing precedent in the United States.
I'll stop you there. Explain to the crowd who may not know what Buck v. Bell is, what it is, because I know, but I think people don't.
Buck v. Bell was the favorite decision of Adolf Hitler and the Nazis. Buck v. Bell was the decision in the 1920s by the U.S. Supreme Court that said you could forcibly sterilize people against their will. It was targeted poor women in particular, poor white women and poor African-American women in the South especially. And it's my view, a lot of other views, people can go back and watch the debate with Alan Dershowitz on this, on the vaccine mandates. And Dershowitz recognized that was a morally offensive, horrifying decision. It was the peak eugenics decision in anywhere in the world. It was of any court anywhere. And it was the foundation of the Nazis' eugenics experiments. They cited that decision as the moral and legal authority for what they were doing in Germany. And so most people had assumed that decision was dead. That I mean, there's not a law student that will stand up for that decision, at least not until now. But here you have Indiana University's lawyers arguing overtly that Buck v. Bell is still good law, and the Seventh Circuit almost taking a wink and saying, yeah, maybe it is. And so, so that will give the Supreme Court an opportunity to get involved. Now, of note, the real reason the suit was effectively quasi-mooted is because after the suit was filed, the University of Indiana completely changed its list of exemptions. And it went from having very narrow interpretation of its exemptions to very broad interpretations. Now at the University of Indiana, you can object to the vaccine on religious grounds, ethical grounds, medical grounds, want to do remote learning, where agree to testing and masks mandates, things of that nature, which dramatically removed almost all the plaintiffs from the case. That's the real backstory of how they took the sting out of the case, and it shows the utility to filing suit. To give another example of that, I believe it's Loyola University in Chicago was going to do the mandate, wasn't going to allow religious exemptions, and a lawyer said, well, I'm going to sue over that, and they reversed course almost right away. So that's the sort of constitutional issue is going to be, part of it's the Nuremberg Code of 1947, which, we had a eugenics era of courts in America from 1905 to 1945 that said they could do forced vaccinations, forced sterilizations, and forced detention camps in the name of an emergency. The same emergency exception was built into the Weimar Constitution explicitly, which is what the Nazis used to seize power. The combination of what happened there led to the United States saying, that's wrong. We'll never do medical experimentation again without informed consent. Both parts, informed and consent. And the Nuremberg Code of 1947 was passed. It was incorporated in a wide range of other declarations and treaties. It has been recognized in the United States courts as governing the medical profession and the state use of medicine in the United States. It is part of the emergency use authorization statute explicitly, which the Office of Legal Counsel at the Justice Department this past week under Biden came up with an interpretation that, in my view, was ludicrous, but contradicted everything every government and court had said before then. They said informed consent only means informed. It means if we're coming to rape you, as long as we tell you about it in advance, it doesn't matter whether you consent.
Informed consent, we're going to tell you about it. And if you don't do it, we're going to strip you of your rights and then grant privileges to others so that you'll consent. And that's consent. And that's not, I won't say extortion or coercion, or that is typically what vitiates consent, not what constitutes consent. And it's over the top. People have sort of now come to the acceptance that consent is just subduing and being compelled to do something under threat of having rights taken away, when that is actually what vitiates consent, typically, at least in contracts and negotiation in general. Sorry, carry on.
In fact, exactly. Because that bridges into so they have constitutional allegations of First Amendment, Fourth Amendment, Fifth Amendment, and Ninth Amendment violations because of all the different ways bodily integrity, bodily autonomy, medical choice, religious exemptions are all implicated at one level or another by one of those constitutional amendments. The Ninth Amendment has been interpreted in the past as effectively protecting any common law right you had at the time of the Constitution, and that couldn't be taken away. So that's where the right against battery, because the failure to informed consent originates from a doctor cannot do something to your body, and no one else can conspire to do something to your body as a medical excuse unless they have your informed consent. Otherwise, it's conspiracy to commit battery, which is not only a recognized tort, but arguably is protected from state action by the Ninth Amendment to the U.S. Constitution. On top of that, the other constitutional claim they're bringing, this only applies to state actors, and that is unconstitutional conditions. The government can't do exactly what you're talking about. Unconstitutional conditions is a way of getting around something like informed consent, where you say, well, I'm not going to take away your right. I'm just going to punish you for the exercise of it. And
I was going to say, I pulled up a chat that said that Indiana U is giving an award to Fauci. It was in caps, and I became immediately nervous that might be false information. This is from News at IU Bloomington. Dr. Anthony Fauci to receive Ryan White Award, take part in virtual ceremony, July 20th, 2021. Bloomington, Indiana. The Indiana University School of Public Health, Bloomington, will honor Dr. Anthony Fauci for his work in HIV/AIDS prevention as a leading expert during the COVID-19 pandemic by naming him the 2021 recipient of the school's Ryan White Distinguished Leadership Award. Okay, in this episode of Bizarro's Universe, what else, Robert?
No doubt. So that's all the constitutional aspects as to state actors or federal employees, federal actors. For the military, and this, by the way, is what exposed the Office of Legal Counsel's bogus interpretation by the Department of Justice under Biden. They went with they tried to force a experimental anthrax vaccine on soldiers back at the time of going into the Iraqi war. They filed suit and won on the grounds the FDA didn't keep its promises and word in a citizen petition context, didn't honor its own obligations, didn't follow its own restrictions, but also because the court found informed consent was a critical factor to examine. And so the Congress came in and passed an amendment that said, well, if the president says under certain limited circumstances that soldiers need to take it regardless of informed consent, then even an emergency use authorized vaccine can be required of soldiers. In the anticipation was military theater. By the way, all these emergency use authorization statutes were passed to deal with a bioweapon released by terrorists or foreign governments. It was not anticipated that it would be just any kind of pandemic would come along. Because if emergency use authorization suffices, why even have an FDA approval process at all? I mean, it does, it's an emergency decree.
To respond to one of the other super chats, now they're going to go rush FDA approval. Typically, what's required in FDA approval in the first place? My understanding is it requires 3 to 5 years of study to prove safety over a prolonged period of time. Whereas if you rush that, you sort of don't have the very assurances that you were giving in the first place through FDA approval. Is that relatively accurate?
I mean, the reason why the FDA prevents you from getting access to a large number of medicines is because they say it hasn't met our very rigorous methodology for approval and acceptance. And I think last I checked it, the average drug took 12 years for approval in the FDA. That gives you an idea for length of time.
No, I remember being invested in some medical stocks. This is back in 2010, waiting for the FDA approval. When FDA gave its approval, they would shoot up 1,000% from one night to the next morning. And now it's like they're gonna FDA approve these vaccines. Without commenting on the underlying technology, because yes, the mRNA technology has been around for years, but when you're talking about specific approval for specific drugs, they need a reasonable period of time to determine and prove safety. Efficacy might be less of a concern than safety, and that's part and parcel of why it's so valuable to get FDA approval. Are they going to rush it through with this, and are they discussing rushing FDA approval through for these vaccines?
There's been public leaked reports that they're going to try to rush it through by Labor Day. And there has been a massive, what looks frankly like a coordinated effort of major employers and state institutions to compel it quickly. Like people are being given 1 week notice. You have 1 week to get the vaccine or you're fired. Things like that, just out of the blue. And again, this has never happened before. So, I'll get now to the employment context.
Yeah.
I get a lot of lawyers out there, Harmeet Dillon, some others, who think this is an uphill battle, not worth the fight. I understand why they think that. It is an uphill battle. But they're forgetting a couple of things. One is this is all novel. This has never been tried before. We have never done national mandates of a vaccine in our history, where we have never had employers doing it across the board, least of all for a vaccine that is being rushed to market, and even least of all for a virus like this one. The Jacobson decision was only about smallpox, where the vaccine had been approved for more than a century, where the disease killed 1/3 of the people that it infected by all ages.
And I mean, primarily had a disastrous effect on young people, if I'm not mistaken.
Yes, that's absolutely right.
And this is where we sort of lose it, to be respectful to Dershowitz, because he is still a great mind. When Dershowitz says this is worse than smallpox, where you disagree with, in fact. So
he's got to quit reading the New York Times. What happened was the New York Times talked about it being more transmissible than smallpox. So people not reading between the lines didn't realize what that really meant or didn't mean. And there's been a lot of that. Now, for the details of the debate about that, again, vivabarneslaw.locals.com, I'll be getting into all the medical debate arguments and evidentiary arguments. But just on the legal side, the Dershowitz agreed with me in that debate. And so people are these courts are applying rational basis review, the lowest possible level. That's one of the issues in the Indiana University petition for an emergency injunction, is that like both the district court and the court of appeals didn't even give us the right legal standard. They put the burden on us to prove that it's not reasonable what they've done. And they've said as long as there could be any reason for it, it was okay. And they cited, in my view, miscited Jacobson for that, though Jacobson's a decision that belongs in the grave with Buck and Korematsu, the trilogy of infamy, as I like to call it, from the eugenics era of courts. And if your liberal friends want to get on a high horse about this, just remind they're back to preaching eugenics, and they're back to cheering masks, and they're back to pushing segregation. I mean, I thought the 1870s Ku Klux Klan was dead, but they're back today in the liberal Democratic Party.
We are literally not far off mutatis mutandis from Korematsu as relates to the unvaccinated. They pose such an immediate existential threat. They are the ones driving the variants, yada, yada, yada. We've got to put them in. I don't want to use hyperbolic language, but we've got to Korematsu that group of people who is putting the rest of the nation at risk. And they don't even see it because they are so enveloped within the moment, enveloped within the fear. They cannot take the required step back to say, this smells exactly like Korematsu. Just fill in the blanks with different descriptions of the people you want to intern, and assess accordingly. They can't see it because, like Dershowitz, he's been, I'll say, isolated for so long, fed the same news for so long, has whipped himself up into this frenzy that it's an existential threat to go on a plane and not know that everyone on the plane has been vaccinated, that it can justify these atrocities in his own mind. And I would refer to Korematsu as an atrocity, as I would Buck. Jacobson less so, because it was only a monetary fine for not getting the vaccine. I mean,
if there was any more compelling argument, the problem with Jacobson was using any rational basis language. But Jacobson is the best case for that because it was a $5 fine worth about $150, $200 today. That's all you had to pay if you chose not to get vaccinated. It was smallpox, and during a pandemic of smallpox, undisputed, uncontroverted pandemic of smallpox. And third, it killed 1/3 of the people and with a vaccine that had a century of history behind it. So you couldn't have a better argument for vaccines than the factual pattern of Jacobson. You couldn't have a weaker one than what we have now. Now, there's one additional constitutional argument I believe will be made down the road, which is there is a equal protection claim, because the way racial discrimination claims work is you don't have to show someone intended to target a certain group. You just have to show there's a disparate impact on a certain group, and then it's up to the government to say why that policy is still justified. But you have a prima facie discrimination claim if a government policy has a known disparate impact on a racial minority group. The city of New York imposing vaccine mandates, segregating their stores, segregating their restaurants, segregating their bars. There's going to be one group primarily excluded from those bars, from those restaurants, from those stores, and it's the Black citizens.
Well, and now I was going to ask this. Now, I've read, and I have not verified it on my own, so collective knowledge of our chat, let me know. I read some stats that 70% of the Black community is not vaccinated or is reluctant to get vaccinated. Is that right?
It varies where the location is, but the number varies anywhere from 50 to 70%. But there is a statistically significant gap, especially in New York City, based on race. And so the mayor of New York is reimposing racial segregation and racial discrimination that will disparately impact the Black community of the city of New York. That's a constitutional violation, and he's going to have to prove it's medically necessary to do so. And I don't think, well, then we'll get to the evidence, which, like I said, we'll be discussing more this week at vivabarneslaw.locals.com. But that transitions into the claims against employers. Now, if your employer is a state government actor, you have both the constitutional claims and the claims I'm going to talk about. If they're a federal government employer, they're not covered by the statute I'm going to talk about. And that is Americans with Disabilities Act. People are assuming that because nobody has ever sued before under the ADA for a vaccine mandate, that means the ADA could not apply. But that's because employers have never done this on this scale before. The closest analogy is requiring nurses to get flu shots. And there, the lawyers did not raise the claim as to whether or not the vaccine or being unvaccinated was itself a perceived disability. They said, hey, this person will have medical consequences or this person has anxiety that will intensify if they take that shot. And the Third Circuit Court of Appeals said that is, in fact, a credible ADA claim. The other part of that, however, is you just look at the law. The ADA law was designed to not just cover disabilities, it was really health status. And if you understand the whole policy, the ADA was amended multiple times, in part to deal with one particular problem, which was the perception that somebody had a physical limitation. And courts were interpreting it in a narrow way. And so Congress would go back in and expand it again, and they would repeat it. In all these statutes, they would say, please, courts, interpret this as broad as possible. All you have to prove an ADA claim is that your employer believes you have some form of physical or mental limitation. You don't even have to prove it substantially impairs your abilities. You don't have to prove you have an actual disability. You just have to prove your employer thinks that you have some physical limitation. And even the EEOC has recognized that perceptions that a person has any deficiency in their immunity is a physical disability. So clearly it's a perception of a physical disability. They may be wrong about that, but that goes to their justification for the ADA claim, not your right to bring one. So while I know it's new and it's novel, and I'll be the first lawyer to bring these claims, people that just assume they can't bring them have not really understood the policy of the law or the purpose of it.
Now, so Harmeet Dillard, from what I understand, is not bringing a specific suit. What was the suit that she's not bringing? And I guess one question is, how does it not come to you for you to bring it if Harmeet won't? Her reaction, one of her associates earlier in the week was tweeting out that there's no ADA claim. And I was like, just think about this for a second. Just think about it logically. What is the employer's reason for requiring it? Does it have nothing to do with your health status? Does it have nothing to do with your physical limitations? Because then they're just discriminating against you for no reason at all. And then they may have a racial disparate impact suit, those that are African-American and Latino, particularly African-American, because then you're using as a pretext, discriminating against disproportionately Black potential employees or existing employees without having any basis for it. No, their basis is they believe that not having that immunity or that vaccine makes you physically deficient. Just like anybody who has any other vaccine deficiency or immunity compromise or immunity limitation. They believe you're uniquely susceptible to getting and transmitting a disease, and that has always been recognized as a actual disability, least of all, perception of a disability. So that's where we disagree. And what it is people are panicking because the EEOC, in very careful language, said that it's not a medical exam to ask whether somebody is vaccinated, because they said being vaccinated is not a disability. They didn't say whether being unvaccinated is a disability, and they didn't say whether being unvaccinated could be the perception of a disability. They deliberately played games with the language because they're reversing and going against 20 years of history at the EEOC, which said merely believing someone could get a disease, the official position of the EEOC until last month, was itself perception of a disability you could sue for under the ADA. That's what's triggering their concern. EEOC acronym?
Equal Employment Opportunity Commission.
Okay.
Which enforces the ADA and other discrimination bills. And they have brought suit multiple times within the last 3 years on the grounds that merely an employer who thinks you could get a disease or be more susceptible to getting it, in that case, and things like travel or other things, that itself is a protected disability. It's definitely the perception of a disability. So they're trying to be careful and hide some things. And by the way, their opinion, just like the OLC opinion, no legal effect whatsoever. It has no legal effect. People that are just deferring to the government. I get that the courts might have a lot of political bias on this issue and be tough to get through, but it isn't because of what the law substantively says or what its policy is there for. On top of that, employees may have if there's no religious exemption law protected, there's multiple statutes that limit employers' abilities, either state law or federal law, that says, in most cases, both, that says an employer cannot prohibit you or force you to take a vaccine where you have a religious exemption. And the religious exemption doesn't require you to go to church, doesn't require your priest or pastor or anyone else to sign off on it. And there are many people can go to vivabarneslaw.locals.com. And I just gave an example of what other people are asserting, very legitimate concerns many people have religiously about this particular vaccine because of how it was made.
Well,
that's another lawsuit they may have. And then the third category, briefly, conspiracy to commit battery, because this is a conspiracy to force you. If your employer said, before you get employed, you got to go down to Joe's bar and get beat up, and then I'll employ you. Like Sopranos style employment standards. That would be conspiracy to commit battery, in my view. And so, isn't this just the same when there's no informed consent taking place? So I'm going to be looking at all of those claims. I believe, and I understand the political process, the stakeholders, the powers that be, a lot of judges don't want people to have this protection. But we have to stand. The idea that Buck v. Bell and eugenics is going to come back to America and legal precedent is morally horrendous, and somebody has to stand up, and by golly, some of us will.
Someone had asked before, people often confound the ADA claims with HIPAA claims. I know we've discussed it before, but just elucidate the distinction between ADA and HIPAA for those who are asking that same question.
So what HIPAA does is HIPAA prevents your employer from sharing your medical information. And it looks like a lot of employers are violating that, by the way. There also may be employer fraud claims. I'll get into more detail of the employer fraud claims. I'll just say this. Employers are saying things about these vaccines that are directly contradicted by the CDC's own fact sheets about these vaccines. I won't get into what they're saying because one guy said what the CDC said and got suspended from Twitter.
We are talking about Dave. We're talking about Dave Rubin here, right?
No. There was a Rubin one, but this is a separate guy, and it took him 48 hours finally to get him reinstated. But employers are saying things about these vaccines that are directly contradicted by the CDC. That may be a potential employment fraud claim.
Joe Biden is saying things that are directly contradicted by the CDC. Once the president says it, who gives a crap if some low, employer says it? It's a world of double standards. That's leaves no standards at all. Write that down. That's beautiful, actually. Okay, sorry. Now I just cut you off and I forgot what you were going to say.
Yeah, so that's what covers all the different employment possible claims. Also, it's important to remember the ADA covers public accommodations and it covers state employers, state governments. So you can and there's the one last set of claims that can be brought while this is an emergency use authorized drug is whether or not it's violating the informed consent principles. That goes to where the OLC has its ludicrous interpretation, in my view. And that too can be a claim because the whole point was to make sure this vaccine was always had informed consent and you didn't run any risk of people being forced to take it or being subject to medical experimentation. That's also a Nuremberg Code claim. And in my view, the Nuremberg Code is enforceable as Jess Kogan's recognized norm of law around the world. America was the one that came up with the idea of the Nuremberg Code of 1947. Multiple courts have said it's enforceable in court. So I see that also as a potential claim that's available depending on the circumstances. But there's a multiple range of claims. Employers that are gambling on this, one other thing people can ask their employer is, have they confirmed that their insurance company will cover any health consequences or cost associated with getting the vaccine? Because it appears there's government actors saying they're not going to give unemployment compensation if you're laid off because of this. And there's lots of reports of health insurers saying they're not covering this. And of course, one last component, the immunity for vaccine companies is broad and complete. So if you're a vaccine distributor, vaccine manufacturer, vaccine producer, vaccine marketer, vaccine doctor, vaccine administrator, you are completely immune from suit. There's a little tiny caveat that allows for suing for criminal willful misconduct. That is brutally hard to prove, and courts are extremely reluctant to allow you to get there. And there is a limited federal government program that might help you out. But of note, they have different causation standards and maybe some other causation standards. They basically impose a strict causation standard on you, and you have to file your claim within 1 year of getting the vaccine. There doesn't even appear to be a discovery exception. So if the injury happens a year and a day later, it's not clear you have any right to even limited remedy under the federal government program. So that's basically this full scope of legal issues with the vaccine mandates.
And so, and I mean, thus far, there has not been a major challenge to compelled vaccination by a private employer.
No, there are a couple of suits pending that are some mostly they're universities. Many of them are public universities or public actors. So there's a North Carolina case that was involved the sheriff. There's a Tennessee case against MTSU. There's the Indiana University case. There's the case against George Mason University that was just filed. Case in L.A. I'll be discussing the details of those, the evidentiary components and the other legal theories of those cases at vivabarneslaw.locals.com. And I'm talking to people about looking at bringing a half dozen or so cases myself over the next couple of weeks.